Okay, we're going to start. Here we go. So today we're going to talk about the federal court system, or the judiciary, or the judicial branch. And the basis of the constitutional power of the judicial branch is found in Article 3, where the Supreme Court was created. Now, a little bit of structure first. The Constitution, or Article 3, only created the Supreme Court. The inferior or lower courts were actually the first act of Congress in 1789 with the Judiciary Act, creating the district courts. Also in 1791, I think they established an intermediate level of appeal courts, or appellate courts, before the cases got to the Supreme Court. So kind of interesting that also the Supreme Court, or federal courts, get their power from judicial review. And we'll talk a little bit more about that when we get into the power section there. Jurisdiction. So let's talk a little bit about jurisdiction. There's three. There's the original, there's appellate, and concurring. Original jurisdiction is where a case starts. Usually that is at the district level in the federal court system. Okay? So that's where a case starts. Very rarely does a case start in the appellate courts. And in the appellate courts, basically the appellate courts review the decisions of a lower court. And then there are concurrent courts, and that comes from our dual court system that was established. National and state courts that were established. So a dual court system, or a concurring jurisdiction, because sometimes an action violates both federal and state laws. Okay, so you might have concurring jurisdiction there, and then they kind of work it out on where they are tried and stuff. Okay, so let's go back a little bit to power. And power comes from judicial review, which the Supreme Court gave themselves, basically, in Marbury versus Madison. But there are limits to the power in the power of the Supreme Court and the federal courts. First, it's the limit. It's passive. They have to wait for an issue to come before them. So they don't just go out and get an issue. They have to wait for until a case comes before them. So they're really, the Supreme Court is powerless until a case does come before them. And then, other limits, people need standing to sue. They call it standing to sue, which means you really have to be personally injured, harmed, or wronged before you can bring a case to court. So there are a few obstacles in the way of a case making it to court, but they do have considerable power. The judicial branch, or the Supreme Court, is really one of the least thought of branch, I guess you can believe, or I guess you can see. People think of the executive branch and Congress, the legislative branch, and very rarely do they think of the judicial branch. It's kind of distant from the average citizen. But okay, so let's just move on to like a who's who, the main players in the federal court system. First, you have the Attorney General. He is the head of the Justice Department. Okay, he's not the Secretary of Justice. They call him the Attorney General. He's the federal prosecutor in federal cases. When a case gets to the Supreme Court and the United States is involved in it, so the U.S. must have been sued or something, the Solicitor General defends the U.S. at the Supreme Court. Okay, and then you have judges in the federal courts. So those are the main players. The judges all federal judgeships have to get approval of the Senate. They're appointed by the president, have to get approval by the Senate. Usually the lower district courts are usually not handpicked by the president. They usually come from recommendations from other officials, and probably because they gave prior political support to the president or the political party. So usually those federal judgeships are somewhat partisan. They're, usually if the president is appointing them, they're going to be from his political party there. Okay. And then, of course, we know that Supreme Court nominations, okay, are appointed by nominated by the president and approved by the Senate. Considerable scrutiny on Supreme Court nominees. They are looked at by the Senate Judiciary Committee. They look at issues such as constitutional precedent, judicial activism, legal writings, past judicial decisions come under scrutiny. Also, other issues such as interest groups, public opinion, media opinion, private actions have been part of the selection process. Let's go to levels of the federal courts. We'll look at a new slide there if I can get it. Here we go. Okay. So levels of the federal court. Let's start at the bottom level here, district courts. It's the lowest level in the federal system. There's 94 judicial districts in the 50 states or territories. So usually, there is a district court, at least one district court in each state. They have original jurisdiction over most federal cases, so federal crimes. And federal crimes, okay, involve civil suits. Okay, so they hear cases involving federal crimes, civil suits involving federal laws, bankruptcy proceedings, admiralty and maritime cases, and immigration cases. And those attorneys, U.S. attorneys, are appointed by the president and confirmed by the Senate. Okay, so that's the district courts. That's the lowest level court. They have original jurisdiction. The mid-level is the courts of appeal. They're intermediate level. There's 12 regions or circuit courts, including the D.C. Circuit. Usually, Supreme Court justice kind of acts as a liaison to these appellate courts, to the Court of Appeals. They don't have original jurisdiction. It is strictly appellate, so nothing starts in the Court of Appeal. Okay, and the last level, the highest court in the federal system, okay, is the Supreme Court. And there are 9 justices. And of course, it's in Washington, D.C. There's the building right there. Okay, they hear appeals jurisdiction through a writ of certiorari process. So they have to ask the lower court, for the case, basically. Cases come to the Supreme Court, and all the Supreme Court justices look at these cases, or at least they are helped by interns and attorneys that look at these cases. And then they ask the lower court for certiorari. They have of course, they are appellate court, Supreme Court. They usually don't have original jurisdiction, but they have very limited jurisdiction. Okay, for a case, very limited number of cases get to the Supreme Court. For a case to get there, there is the rule of 4, which means a minimum of 4 justices agree to review a case. And then this the process is very difficult for a case to get to the Supreme Court. So a writ is granted. When I talked about the writ of certiorari up there, a writ is granted and the lower court sends to the Supreme Court transcripts of the case that has been appealed. And then attorneys for the petitioner and respondent submit to the court written briefs outlining their positions of the case. Also, interest groups also might add certain briefs to the court. Those are called amicus curiae, or friends of the court. They may be sent to support the position of the petitioner or the respondent, sorry. Okay, and usually you only get about 30 minutes in front of the Supreme Court, each side. And then the Supreme Court, asks questions and, they get grilled. The attorneys get grilled, but it's a pretty interesting process. Okay, that's it for the federal court system.